congratulate you on the great honor of having been nominated by the President to a lifetime position on the federal judiciary. I have practiced before federal judges. I have been inspired by them, terrified by them, various things. And it's a position of great importance that you will be entering into, assuming a successful and rapid conclusion of the nomination process. As I noted to Judge Bacharach, don't be discouraged that there is not a lot of turnout. What you want is uneventfulness, and so far it looks so good. As I said before, judges must respect the role of Congress as the duly elected representatives of the American people. You must decide cases based on the law and the facts. You must not prejudge any case, but give fair and equal hearing to all parties who come before you. You must respect the precedent that provides the framework for your decision, and you must limit yourself to the issues that are properly presented to you by the case at hand. Can each of you satisfy that standard?
Senator Whitehouse, let me just say that it's my opportunity to be...
Apply them during my term on the bench, and my intention would be to continue to do that.
And let me ask you the same question that I asked Judge Bacharach about juries. A jury trial can be an inconvenience. It can press on the schedule of the court. Particularly in criminal matters, very often there is enormous incentive applied to try to avoid a trial. And at the same time, the jury appears no less than 3 times in the Constitution and Bill of Rights. And as I said, none other than de Tocqueville described it as a means of the sovereignty of the American people. I consider it to be not just a fact-finding tool, but an important institution in the American system of government. And I would like to hear your thoughts on that, as you will be in a position to encourage or discourage access to a jury in the course of your duties. Judge Grimm.
Thank you, Senator Whitehouse. In
the civil arena, in the criminal arena, as a lawyer, as a prosecutor, and as a practitioner, and I've also obviously observed them and interacted with them as a judge. I am fond of telling them, because I believe it to be true, that next to military service, there is no greater service that a citizen of the United States or the state of Florida can contribute to our democracy. I found juries to be amazingly attentive to their duties to serve and serve consistent with the oath that they take despite the inconvenience. And I believe that it's both a fundamental right and responsibility of citizenship, and am honored to be a part of the process that in which that citizenship duty is exercised.
And Judge Davis, is it true that you have been nominated to fill a judicial position that is a designated judicial emergency?
Yes, that is correct, Senator.
Good to know. Let me just conclude by...
you gave on December 16th, 1995, to the Clay County NAACP luncheon. In this speech, you refer to a number of historical events and try to describe the significance of those events as they relate to race relations in the world. There are a couple segments of the speech that I just wanted to talk to you about, make sure I understand correctly. One of the statements began with an event that occurred on December 9th, 1994. And in summarizing that event, you said Dr. Joycelyn Elders, Surgeon General of the United States, is asked by the President to resign after being misinterpreted about student sex education, reminding us, lest we forget, that politically correct is spelled with capital letters for melanin-impregnated females. Just a few paragraphs later, you refer to another event related to a Surgeon General nominee, where you said on February 2nd, 1995, President Clinton nominates Dr. Henry W. Foster, Jr., former chair of the Department of Obstetrics and Gynecology at Mary Medical College, as Surgeon General, but the Senate filibusters so as not to confirm the doctor because of a controversy over the number of abortions the doctor performed early in his career, reminding us, again, lest we forget, that politically correct is also spelled with capital letters for melanin-impregnated males. Can you tell us sort of what you meant by those two statements, what you were referring to?
Thank you, Senator, for posing that question. I actually have given some thought to those comments and others in connection with this hearing. As a preface, let me say that I've given a number of speeches. I think I submitted about 178 pages of speeches to this committee. I didn't realize until this process that I had given as many speeches, and I had never taken the opportunity to look back on them as a whole with an objective and critical eye. I've had an opportunity to do that now. The speeches, the comments that you referred to, as well as some others, and sprinkled through other speeches that I've given over some 30 years since my graduation from law school, have been part of a body of work of speeches that have been designed primarily to engage people in the community in which I live around issues concerning matters of race. My heritage and my experience causes me to believe that matters of race remain among some of the most serious issues that we face in America, and that was no less true in the community in which I live, practice law, and sat as a judge. If you look at the body of work over the years that I have been publicly speaking, I think what will be discerned is that the thrust of those was to get people engaged in trying to address problems surrounding racial issues in their community. The thrust was to, when directed to children, for example, was to have them embrace education as a means of being part of the solution to some of the problems as opposed to part of the problems. I had the distinct pleasure around this subject to co-chair a citizen study that involved over 9 months of consideration every week for 2 to 3 hours a week, matters of race from people of all walks of life in the community, white, black, Hispanic, Asian, men and women who volunteered to come address this subject. The result of that effort was to present a report in the community in which I live about racial matters and their impact and solutions that might be found. One of the things that came out of it, for example, was an annual report in which the community actually looks at and examines solutions to problems and identifies ways to do that on an annual basis. Having said all that, if you'll allow me, Senator, because it's a sensitive subject and one that I'd like to get some clarity to if I could. Having said all that, I have come to the conclusion in looking at those specific remarks and others that despite my use of rhetoric and hyperbole and exaggeration as a means of persuading and motivating people to be involved, that some of the comments, and those are the tools that I just identified, are tools trial lawyers learn to motivate and persuade people, that despite that, I have found that some of the comments were inappropriate. The ones that you mentioned were inappropriate for the reason that an impression could be gotten from them that somehow the court maintained a racial prejudice. I have concluded in the future that I will not make those kinds of comments. I will not use those kinds of tools to motivate and persuade people because I don't believe it's fair for possible participants in the court process to have to wonder about whether the court has a bias or not. Having said that, I don't intend to stop the work in the community that I've begun and have worked around for very many years because I think it's important for judges to be involved in their community around issues that are important to the community. Finally, if you give me this last opportunity, what I would hope would happen in the committee, Senator, is that you would look at my entire record of public service, both as a prosecutor and as a judge, and find in it, as I have, that there has not been one formal complaint or informal suggestion of racial bias on my part, and that if you look and find, as I did when I looked, and that what exists is a reputation that I have been a fair, impartial, informed, and respectful judge, and that if I'm reported out of this committee and confirmed, I can assure you that that's a reputation I'll continue to earn.
Thank you. Okay. With the chair's indulgence, I'd like to just follow up on this a little bit more and make sure we cover the ground. Thank you for your answer, and I appreciate and agree with the fact that there are a few issues that have been more contentious in American history or that are more important to our day-to-day lives than those issues that involve race relations. And so I appreciate your concern for this issue. I also appreciate your statement to the effect that as a sitting judge, it would not be your inclination to make statements like those ones again. But I want to follow up on another statement made in the same speech on kind of a different vein. You referred to the fact that on September 12, 1995, and I quote, 400 people protest outside the home of Supreme Court Justice Clarence Thomas because of his opinions in rulings affecting affirmative action and voting rights, reminding us lest we forget how easy it is for some of us to forget history, close quote. So to some extent, I think what this is insinuating is that that particular member of the court, Justice Thomas, has forgotten history. So my question to you is, as an Article III judge within the federal judiciary, does this statement reflect, or would you otherwise experience, difficulty employing decisions rendered by the Supreme Court authored by Justice Thomas?
Not at all, Senator. Actually, that particular reference was to the sentiment as being expressed by the protesters. I respect Justice Thomas as a sitting member of the United States Supreme Court. When he is in the majority, his decisions are the law of this land. And as a sitting judge, Article 3 or otherwise, I'm bound to support and apply that law. And that would be that has been my understanding, and that would continue to be my intention here out, whether I'm confirmed or not. As a judge, I think the Supreme Court's authority is when applicable, is controlling.
So your criticism in there was not directed toward the justice; it was directed toward the protesters. Do I understand that correctly?
I was echoing the criticism of the protesters in trying to motivate an audience to action around matters of race.
Okay. Does this also fit into the category of statements that, as an Article III federal judge, you might not be inclined to make?
I think it does, only because I am confident it is improper for sitting judges to comment on the decisions and disagreement with decisions of sitting judges. It not only would be proper as an Article III judge, my acknowledgement to you today is that it was probably improper for me to do it then.
Thank you. Thank you. I appreciate that.